May 8, 2012. It's just Dunder Chief. Just want to share some thoughts regarding the Court of Appeal of New Brunswick. Just some basic facts about it. Court of Appeal of New Brunswick gets its jurisdiction from the Judicature Act, which is the New Brunswick statute. And what the Court of Appeal does, they're a court of review. What the purpose of the Court of Appeal is to review lower court decisions to see if the lower court decision was in error. Now the errors the Court of Appeal is looking for is they are looking for, did the judge demonstrate reasonable apprehension of bias? The second thing they're looking for is, did the judge err in fact, as in finding a fact? Did the judge, thirdly, err in application of the law? And fourthly, did the judge infringe on the litigant's right to be heard? Now those four concepts, I'll go over them real quick again. Number one, it's your right to be heard. Number two, reasonable apprehension of bias. 3, error in fact. 4, error in law. Now I'll expand on those a little bit. As a litigant who is appealing a decision, one goes to Court of Appeal, and if it's a final decision, as in the litigation is over, then one can go straight to appeal. You have a right to go straight to appeal because there's no other remedy for you. Now, how you know that an action is completely over is if someone filed an action to basically for breach of contract against another party, and they're claiming the other party breached the contract, and they want the court to make a decision to help make them whole. And then at some point along the way there was a decision made that ended the litigation. The person cannot go forward anymore with the litigation because the action was over. Then that's considered a final decision, and one can go straight to appeal. Now if you're uncertain if your decision is final or not, most of the time they're not final, and if you're even unsure, the better thing to do is to file notice of motion for leave to appeal, because once you're granted leave to appeal, there's no issue from that point forward with the Court of Appeal. Now when filing for leave to appeal to the Court of Appeal, one files a notice of motion for leave to appeal. Now in that motion, it's going to have to be argued why the judge either violated a litigant's right to be heard, demonstrated reasonable apprehension of bias, erred in law, or erred in fact. Now if one can convince the judge, a single judge was reviewing the motion, that the judge erred in law in a substantial way that's not peripheral and actually kind of matters in a major way, then one should be granted leave to appeal. Now the 3 conditions the Court of Appeal is looking for is, number 1, in considering whether to grant leave to appeal, the judge is going to consider, is there conflicting decisions basically between lower court judges. If there's a conflicting decision, then they have to rule on it to settle that discrepancy. Number 2, they're going to be looking to see if they're convinced the lower court decision was wrong. And number 3, they're going to be looking at overall social implications, as in, is the implications of this decision have larger implications than just between the 2 parties that the decision was rendered either for or against, as in if there's a larger social context that's being affected by this decision, then it puts it in a level of importance that means that leave to appeal should be granted so that there's a final appeal on the matter, so there can be an authoritative decision rendered. So considering all that, when one's filing a motion for leave to appeal, they have to file a motion for leave to appeal with a supporting affidavit. In the affidavit, one places the facts that they believe are relevant for the judge to decide. They want to include as an exhibit a copy of the decision they're appealing, and any other material they want to use at the hearing. Now keep in mind, a judge considering granting leave to appeal or not, for the most part, is going to confine themselves to just the facts that were before the lower court, as in only the evidence that the lower court was considering, so that the leave to appeal judge can see, based on the facts and evidence and material before the court, that the lower court decision is impugned, it's in question, it's possibly in error. Now I'll go over quickly those 4 conditions again. Now there's the big one is one's right to be heard. If your right to be heard has been violated, you should be granted leave to appeal, and you should be granted an appeal, because a judge's job is to hear both sides of a litigation completely and fully, and only after considering all the relevant facts, information, case law, and argument that both sides presented, can then the judge make a decision that's based in law and fact and apprised of the whole situation. It'd be premature for the judge to make a decision without having fully heard the parties. And there's very rare cases where it would be justified the judge didn't actually hear both parties completely. The second condition is reasonable apprehension of bias. And the Supreme Court of Canada has defined reasonable apprehension of bias as a reasonable person apprised of the facts, knowing all the facts, looking at the situation, it would be reasonable for them to think that bias was involved. It doesn't mean that bias was involved. It only means that it looks like it might have been, and it's reasonable to presume that. That's what's very strong about reasonable apprehension of bias, is that it doesn't matter if bias existed or not, and only if it appears that bias existed, that can taint the whole proceedings, no matter how reasonable the decision which followed the tainting. The whole proceeding should be overturned and start from scratch again with a judge who did not demonstrate reasonable apprehension of bias. And it's the judge's duty, judicial duty, to not allow their conduct to raise the specter of reasonable apprehension of bias. And that could be as simple as favoring one side over the other without good reason, or consistently going one direction toward favoring one litigant over the other when the facts and evidence or argument do not support such a conclusion. Once the reasonable apprehension raises its ugly head, the whole proceedings are tainted and they need to start over again. So the third condition is errors that the judge may have put in writing, either from, if they wrote a decision, there might be an error in the decision, or errors from things that were stated at the hearing that can be put into evidence by utilizing a transcript of the hearing. And what an error in fact is if the judge came to a conclusion that was not based on the facts of the case. It's called an error in fact. And the judge should not have found that fact to be true because the evidence did not support the finding of that fact. Judges make mistakes, and this is a mistake that comes up often. The other one is, the fourth category is error in law, and that means an error in the application of the relevant laws. That is either application of the relevant common law, which is decisions of judges that came before, or statute law, which is statutes and acts of the province, or federal statutes. When the judge misapplies the law in that way, it's considered an error in law. It's called reversible error, which means that someone is entitled to have the decision reversed based on the errors they found. And it's up to someone who's filing leave to appeal to actually point it out to the judge who's considering granting leave to appeal or not, they have to point out all these 4 different categories, exactly where it happened, and show the case law supports the litigant's position on the matter. So it's important to consider that when considering filing a motion for leave to appeal or an appeal. The paperwork is fairly straightforward, and it's a matter of preparation. The key time limits that people need to keep in mind is that if there's a decision that was rendered from the date of the written decision, as in the decision's dated the first day of the month, then one has 7 days within which to file leave to appeal. So, not counting the first day, it's 7 days, not counting the first day, to file leave to appeal. If you miss that deadline, you have to file a motion for an extension of time for filing and serving the notice of motion for leave to appeal, which is fairly straightforward, and for the most part the judges should grant the motion for an extension, because the rules of court, the spirit of the law, all states that people should not be barred from the relief a court can grant by a simple technicality or a breach of a part of a simple rule. The law, I think the quote is the rules of court are the vehicle by which the law can be transferred. They should not be a barring someone from relief that the court could otherwise grant. There's a lot of great quotes on that I could put in the description of this video for your reference. The other time limit just to consider when considering an appeal is if one is appealing a final decision, then they can actually file straight for appeal, and if you're filing straight to appeal, you have 30 days, not including the day of the decision, to file for the appeal. What's interesting is that the leave to appeal versus a straight appeal, it's actually in your interest, just in case, to file leave to appeal, because at least then the judge can see very clearly, okay, this is there's good cause to file, and they will grant a decision in favor of an appeal, which means that won't be an impediment to actually getting one's case before the Court of Appeal of New Brunswick. So that's all for today, and thoughts on the Court of Appeal of New Brunswick. That's all. Justice done dirt cheap, May 8, 2012. Thanks for listening.